About a month ago, YNW Melly's team filed a motion to dismiss the case based on tampered phone records and testimony from Michelle Boutros. The prosecutor officially responded, completely destroying these claims. And boys, let me tell you, it's bad. This is a 10-page document that just goes through a list of reasons why Melly's team is basically delusional. They talk about the tampered phone records towards the end of this video, so stick around, hit subscribe. Let's get right into it, boys. All right, so we got state's motion to strike the defendant's second motion to dismiss for government and prosecutorial misconduct in violation of the defendant's due process rights. They filed a motion to dismiss. I covered a video. Here's the annotation right here, so you can watch that first if you want to. On October 19th, the Honorable Court entered a written order denying the defendant's motion to dismiss. In denying said motion, the court considered the defendant's motion, evidence presented, arguments of counsel, and the court filed an applicable law. The second motion to dismiss re-alleges all of the grounds in the previous, so they're doing it over again pretty much. Because the defendant has already made this argument at great length, and this honorable court having ruled against the defendant's motion to dismiss, the defendant is stopped from raising his argument in his subsequent motion under the doctrine of res judicata, which means they already ruled this in court, so it's like going over it again pretty much. By the defendant's own admission in paragraph 5, he re-alleges all of his previous grounds, and then they explain res judicata with a bunch of other cases right here. Furthermore, the newest evidence in this case portrays a different version of events than what was previously relayed to the court, so they're saying they changed it now. A little bit. On November 20th, 2023, the court permitted Detective Moretti to testify at the defense motion to suppress over the state's objection, as no witnesses can be called at a motion to suppress regarding the credibility of witnesses. And then they cite more states. They cite more cases where that happened. The validity of an affidavit for a search warrant is determined not from witness testimony, but from the four corners of the affidavit. Okay. Despite the state's objection, this is the first time the court heard from Moretti regarding what took place inside the conference room on October 12th, 2022. Moretti unequivocally denied ASA Michelle Boutros' allegations. Yeah, so remember I made a video about Boutros lying too, because she changed what she said on the stand compared to what she said in real life with Moretti, and she worked with him a bunch after for days on end. But then on the stand she said she stopped working from him and then went on with her life and didn't work with him ever again, but that was false. While ASA Michelle Boutros alleges Moretti solicited Deputy Gurrell to lie in a report during this 38-second encounter, it was only 38 seconds, neither Gurrell or Moretti have said Gurrell was present for the execution of the search warrant on Miss King's phone. In fact, both law enforcement officers have affirmatively stated Deputy Gurrell was not present. Also note that Moretti testified in February, which is prior to when an internal inquiry was conducted and Brady notices were sent out. Boutros originally testified both in deposition and in front of the honorable court that she was unaware Moretti was going to serve the search warrant after this interview took place. She says, I was unaware that he was going to serve it during the statement of Miss King, and I really hadn't even thought about it. I never had that happen before. I just assumed he would serve it that night or in the morning after they left, and he didn't tell me he was going to, but we didn't discuss that he was going to do it during the statements. Moretti emailed Boutros at 7:30 in the morning of Miss King's statement, so before they met with Melly's mom, asking for her to print the search warrant and informed her that he would have someone from BSO present after their interview. Miss Boutros responded, no problem, at 8:35. In part 2 of Miss King's statements, Boutros is an attempt to calm Miss King down, explains to her the reasons why. This is what they have on audio right here. We don't give people a heads up when we are going to confiscate their phone is because it can end up at the bottom of a canal. Can be modified, and there are millions of things you can do to a phone if you have a heads up that the phone is about to be confiscated. I mean, yeah. Boutros also testified that she did not know what Miss King was attempting to do with her phone. However, in part of the audio, Miss King's statement, Boutros can be heard saying, it looks like you were trying to turn off your phone. So that's the first lie right there, or second lie. I guess the first one was a lie about her not knowing that he's going to serve the search warrant. Additionally, in the audio statement, which takes place after the alleged solicitation of Gurrell reported by Boutros, Boutros calmly and professionally informs Miss King the following. I watched the exchange between you and Moretti, and so did you, Mr. Trackman, and you didn't want to give the phone up, and it's understandable, but he has an obligation with the search warrant to take your phone, and from my perspective, which is the same as Moretti, I'm not just defending him, it looks like you were trying to turn off your phone. Moretti then states to Miss King, both the buttons were pushed, and the screen to turn off the phone popped up. Boutros then states, and I saw it too. And there were people commenting on my video saying that she lied, saying that she didn't lie. That is a clear lie. In real life, she said she didn't see anything. Like, she just saw her fumbling with her phone. But then in the audio, she said she saw all that. Miss Boutros is 100% a liar. Like 100% if they have audio that she lied on the stand. I couldn't tell him, Mr. Trackman, you know, she's going to have her phone taken away because you could have come in with your neighbor's phone or no phone at all. All parties have a calm discussion about what took place. Boutros eventually states, but you have to understand we have a job to do, and I don't know what better way would have been to do it. Damn. So during the moment, she was saying it was like fine the way he served the search warrant. But then now on the stand, she's basically saying she didn't like the way he served the search warrant. All her credibility out the window, bro. In deposition, Boutros stated that she immediately reported Moretti to her supervisor, Mr. Killoran, and she informed him she would no longer work on this case and no longer work with Moretti. On page 39, defense counsel follows up saying, and you already indicated you were done having anything to do with an investigation because you're not going to work with or investigate or have anything to do with Moretti. Boutros says correct. Contrary to Boutros' testimony, she did continue to work on the case with Moretti. 3 subpoenas signed by her 5 days post alleged incident. Bank of America, Cash App, and Western Union records. Screenshots of text messages at 10:14, 2 days after the alleged incident. Boutros initiates contact with Moretti, asking if he has any luck getting into the phone, and follows up with asking if he can determine when the phone was activated. So she's clearly still working with him days after, but on the stand she said she did not, so this lady's just a liar. Boutros testified she followed up on behalf of Miss Kane to find out when she would get her phone back. However, asking if Moretti was able to figure out when the phone was activated goes further than getting a time frame in the return of the phone. They just point out that she capped. She lied so much. Emails between them on 10/17. Moretti emails her 3 subpoenas and provides an update on the case. She forwards the 3 subpoenas to her assistant. She signs the subpoenas 5 days after. All right, so now that they've established the grounds that Boutros is a liar, in addition to relying on its previous grounds for this motion to dismiss, the defendant now asserts new unfounded, baseless accusations of prosecutorial misconduct not rooted in fact or evidence. Counsel alleges that while preparing for this new trial and going through what they define as call data records and cell site location information records provided by the state in discovery, their expert informed them that the phone records for Dontavius Withers and Christopher Thomas contained notes from a third party, which was not the type of information he had seen on similar types of records. Their purported expert also stated he indicates there has never encountered these types of headers before. And so because of this, they assert their records have been tampered with. So there was headers at the top of these records with notes of, I believe, Moretti just writing notes on the cell phone records that they gave over to them. That's all it was. It wasn't tampered records. I knew it. I made a video about that too, like a month ago or whatever. I knew they weren't actually tampering with the data. I just figured it was someone noting on them. Despite getting exactly what was asked for new prosecutors on this case, the defendant continues to blame Christine Bradley in this new motion. When counsel brought this up, Raven Liberty, the lawyer that got arrested on video, pull up their exact records in court to be reviewed. Having expertise in these types of records, the undersigned immediately recognized what the counsel was referring to, albeit their interpretation being completely misplaced and uninformed. Prosecutors for the state informed the defense that the defense must have been provided with documents that had been worked on by Miramar, not the originals. This statement is conveniently misquoted. What the undersigned informed Miss Liberty upon review of the records was not only did Bradley provide you original copies within the folder, but she also provided you with a second copy that included Moretti's notes, something she did not have to provide in the first place. So she gave them over 2 different copies, the originals and Moretti's ones with the notes. That's all they did with filing a motion to dismiss this case. So basically, Melly's lawyers were kind of grasping at straws here, like grasping at nothing, dude. Furthermore, the undersigned informed counsel for the defendant that the headers were just fine and not in fact tampered with. During the first trial, a records custodian for T-Mobile testified to the authenticity of the records. Defendant alleges that the altered or tampered with records were sent back with the jury, however, provides no evidence to back such claim. Okay. To shut down any more of these conclusory, unfounded allegations, the undersigned provides fresh copies of the records to counsel via USB, which was supplemented in discovery and signed for receipt on November 8th, so like a month ago. To further shut down any claims of tampering, the undersigned was forwarded the exact emails with attachments from T-Mobile to Moretti back in November of 2018. So they sent the original copies that T-Mobile emailed Moretti. They sent them more than they needed to. And it came back with a motion to dismiss from the defense because they were desperate. That's pretty much what happened. Defendant's motion, he alleges defense counsel became aware that the 2 files that are alleged to be the phone extraction of 9807, along with Williams and Thomas's phone extractions, are not phone extractions, but rather reports of various parts of the phone, but not the entire extraction the state presented to both the defense and the court. This assertion is confusing on its face and seems to be mixing up cell phone company records up with a physical phone download. Therefore, the state cannot properly respond to such statement. Basically saying, y'all are confused and whatever you're saying is fucking stupid. That's what they're saying right there. Furthermore, it appears that this complaint that they don't have the entire phone extraction. However, on previous occasions in court, counsel has admitted to having a copy of the download at some point in time. So they're capping again, low-key. State has been made aware that the defense copy of the device download was no longer working. The newly assigned assistant state attorney have new downloads being prepared for the trial. While normally a copy would be provided, counsel for the defendant had indicated some nude photographs of an underage female were present on the phone. The state cannot knowingly provide a device download with such photographs on it. The state offered to have its digital forensics examiner remove said photographs. However, counsel for the defendant informed the state that they would then argue the phone was tampered with, and therefore, as with any case involving child P, proper procedure requires counsel and their experts to come to the state attorney's office to review the device downloads. Okay. The defense complained that there was CP on the phone. You know what I'm talking about. Melly and his girlfriend, because they were underage. His team is making this difficult, bro. They're complaining about what's on the phone, but then now they're saying that's tampered with if they take it out. So which one do you want? Do you want it taken off or not? Furthermore, at this time, more evidence and testimony has come to the court's attention, which directly contradicts all allegations against Moretti and Christine Bradley. Ooh, okay. Making a complaint against an individual can be done by anyone for any reason. Complaints alone are not valid grounds for dismissal, nor are they valid for a jury to hear, because anyone can make one without a valid basis. That is the purpose of an investigation, and just as the defense asserts for their client, everyone is innocent until proven guilty. Currently, the only evidence before the court merely has multiple parties saying different things. The remaining portion of the defense motions are purely speculation, conjecture, and riddled with misstatements. Baseless, conclusory, and disingenuous accusations have no place in court. Due to the deficiencies of the defense motion, the state hereby moves to strike his second motion to dismiss. So that was basically the prosecution shitting on Melly's motion to dismiss on tampered phone records that I made a video about, shitting on Michelle Boutros' entire testimony, pointing out that she lied several times on the stand. It's 100% a fact. I'm gonna go to my old video, dude. There was people saying I was wrong. I'm like pretty sure. She didn't lie. In her testimony, she said she saw Jamie fidgeting with her phone but couldn't tell exactly what she was doing. She said if she had to guess that Jamie was trying to turn off her phone. So I don't get why people think she was lying. Because on audio, she was like convinced, no, I saw her do it. She said, no, I saw her do it too. To Moretti, like she saw it. She was present, saw her doing it. So on the stand, she should have been like, yes, she was trying to turn off her phone. Not, she was fidgeting with it. I don't know. She wasn't, I couldn't tell. In person, you said she was. So which one is it? You couldn't tell? Or was she trying to turn off her phone? Okay, there actually is people saying she still lied, okay? Just because she talked to the detective after saying she didn't work with him anymore doesn't mean she lied. She has a job to do. She's not a kid and just stops talking to someone because she don't like them. This is not how the real world works, especially in government office setting. Dude, she signed subpoenas for him 5 days after when on the stand she said she never wanted to work with him again. So, what are we doing here? She was capping. Yeah, that's pretty much it for this video. If you're new to my channel, subscribe. Follow me on Twitter and Instagram. Fucking love you guys. Peace out.